Now I'm going live on Instagram. Hi, YouTube. Hello, Instagram. Let me put my title in. Yeah. All right. And let me pin this. I'm going to turn today's theme music on. Happy Thursday, everybody. Hey, Kid Ubuntu. How are you? Hope you're having a wonderful Thursday. I'm giving everybody about 3 to 5 minutes to get themselves in the live stream. In the meantime, I have Cash Doll playing in the background because she's actually going to come up in our discussion today. Okay? So, hope you guys are having a great Thursday. I can't rap, guys. Ice me out. Ice me out. Y'all like Cash Doll? Y'all like Cash Doll? I think she's fun. I like over-the-top characters. And that's what she is to me. We're just going to do this. Ooh. Got all my cleavages out. Okay. I ain't gotta get naked for no tennis bracelet. I need 20 bands for okay. So I really like the song. Okay. I'm gonna give y'all a little bit more time to get in here. Facebook, YouTube, Instagram. Okay, y'all are okay. Guys, we have a lot of cases to go through today. This is just a list of cases. This is not even like the details. When I tell you we have pages of stuff to go through, we're going to have fun today, okay? Ice me out. Ice me out. Ice me out. Hey, ya is the what? I'm not exactly sure how to pronounce your name. But thanks for coming in. We're about to get started on the Legal Dish. Hi, One True Empress. How you doing? Actually, let me wave to everybody. How rude of me. We're listening to Cash Doll in the background. But let me turn it off now, okay? Okay. So, happy Thursday, everybody. Welcome to another week of my live stream. I think I have found the name for my show. If you have not been following me on Instagram, I am trying to figure out a name for this thing, and the ones that I was thinking of were not really hitting. Actually, they were already taken. And I was talking to one of my very good friends today, and she gave me a really great idea. So I'm trying out NPL Legal Dish, seeing how that sits with me, how it sits with you. Tell me what you think of the name, okay? But before you even tell me what you think of the name, there might be some of you here who do not know who I am. One True Empress is not one of those people. She is an OG. She is always here. She's been here, standing strong. Okay. But hello, hey, Lorenzo. If you don't know who I am, if this is your first time seeing me, hearing my voice, my name is Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting LLC, a business formation firm. What that means is I help you get your business paperwork together. Things like getting your EIN number, filing your articles of incorporation with the state, making sure that you have contracts, how to hire employees, helping you get trademarks and just protect your intellectual property in general. I help you with all of that stuff. Hello, El Toque de Jesus de Jesus. I help you with all that stuff, okay? And this is my business partner, Dallas. You know, he keeps the show afloat. If you have need of any business formation services, or you want to see some of the things that I can help you with, I encourage you to go to the link in my bio, linktree/NPL consulting firm, linktree/NPL consulting firm, linktree/NPL consulting firm. There you're going to find things like a bunch of free ebooks that you can download, including 2 out of the 3 books of my intellectual property series. You're going to find access to my podcast that I release twice a month now, where I interview entrepreneurs in different areas, and just to kind of give you inspiration as an entrepreneur, and also to show you that every business has kind of the same concerns. And that's also where you're going to find tickets for my intellectual property webinar, guys. A lot of you guys, the question that I get asked the most by people when they approach my business is, or the what they want most is, how can I get a trademark? How can I get a copyright? How can I get a patent? So I have put together a webinar for you guys that is taking place March 20, 2019, March 20, 2019, March 20, 2019. Tickets are on sale right now. If you click the link in my bio, it is the first button, okay? And it's next Wednesday. Now, when you purchase your ticket to the webinar, you don't just get the webinar, you get all 3 of the books in my intellectual property series: the patent, the trademark, and the copyright. The copyright ebook, nobody else is getting it but webinar attendees, okay? And you're also going to get a copy of the webinar when you're done, so that you can watch it again at your leisure, because it is going to be a lot of information, all right? So those are the things that I have to tell you about today. Thank you, One True Empress. Dallas is emphasizing the date by dropping a bottle on the floor. So if this is your first time watching the show, every week I pull stories from the news that have to do with pop culture, celebrities, but also have a legal aspect to it. And I pull those aspects and I explain to you what went wrong, why things are happening, and I also pull lessons so that you can apply it to your business. All right. So today we have a long list of cases, so we're going to get started. But again, before we go into the cases, remember to get your tickets for my webinar, go download the ebooks, and go listen to my podcast. Your girl's trying to come up in these streets. Okay. So the first case that we are talking about this week is a case having to do with Adidas. Adidas is being sued for trademark infringement, okay? And I'm going to tell you how it happened. So last summer, this guy named Abram Levi, who was an entrepreneur living in California, he filed a trademark infringement against Adidas for using the phrase "you're never done." And alternatively, the initials YND, okay? Why did he file the trademark infringement? He created that phrase in 2014. He applied for the trademark in 2016, and he also applied for trademarks for the variations "never done," "we're never done," I'm never done, all right? So he did all that. He got all his ducks in a row. He was in licensing negotiations with the company that handles licensing for Adidas. So they were talking, they were like, "We like your phrase, we want to use it." He's like, "All right, let's come to the table. Let's see if we can come to some kind of agreement." Deal never went through because Adidas copied his slogan and started putting it on merch, and then started selling that merch outside of the country, I believe in Germany. Okay. So Levi is suing. He says that they're causing confusion in the marketplace because it's a slogan that he uses for his business. They did not have permission to use the slogan, and he wants damages and legal fees. Now, in response, Adidas is basically saying, now remember, Levi, he filed in California. Adidas is saying, we didn't use your phrase in America, so you can't sue us. That was their argument, was that we didn't use it in the United States, and that's where your trademark is. So, tough titty. The judge, however, disagreed and went along with Levi and said that Adidas definitely infringed on his trademark. Okay. So now they've reached out to Adidas, but Adidas has not given any commentary. So I guess we're going to wait and see what happens. But I'm assuming that they're going to have to pull all of that merch. Oh my gosh, guys, I totally forgot to remind you. So this week, if you guys have any commentary about the stories, I want to pop you guys in. So if there is a story where you have a question, if you actually want to be on the live with me, let me know, send a request, and we can pop in and go back and forth a little bit. All right. Yeah. So that case is, Adidas is stealing from a small business owner. All right. Next case. Hey, Miss Whitney, how are you? Next case we are talking about this week has to do with a Supreme Court case hearing. So there is there is a clothing streetwear line that was launched by these two skateboarding enthusiasts. Okay. The name of the clothing line is spelled Fuct. Now, for those of you with sensitive ears, please forgive me, pronounced fucked. So they started the fucked clothing line and they tried to trademark it. Okay. Federal government said, when you tried. Yeah. So the federal government and the USPTO office basically said, girl, we're not going to trademark this swear sounding word, okay? Because in the USPTO, there is a morality exception. So even if your trademark is unique, if they feel like it is offensive, if they feel like it is scandalous or immoral, shocking to sense of truth, decency, and propriety, disgraceful, offensive, or disreputable, then they can deny it. Okay. Yeah. One true empress. That's funny, right? Okay. They can also deny it for being vulgar, lacking in taste, indelicate, and morally crude. So this is what the federal courts have decided when, reasons that you can deny a trademark. However, one of the founders of the clothing line said, I want it to be offensive. That is the reason why I named it that. Okay. So he appealed and he won because of free speech. Basically, they were saying that barring him from trademarking this was not allowing him to trademark this was a free speech violation. And this case actually helped another later case where this Asian music group wanted to trademark the name The Slants for their group. And they used this case and won the ability to use the slants, even though it would probably be considered a racial slur. All right. It was also a case that the Redskins stood behind because you know that they don't want to change their racist name. Dallas, come on. Okay. And the argument of the courts at the time was that you can use the name, we're just not going to give you a trademark for it. All right. So they weren't saying that he couldn't use the name. They were just saying that they don't want to give him a trademark. Now, there is a hearing on April 15th to see what the final decision is. So I want to know from you guys, what do you think? Do you think that this streetwear line spelled Fuct and pronounced fucked, do you think that they should be allowed to get a trademark? Now, you guys can pop in if you want, or you can just write your commentary, but I want to hear from you. Do you think they should be able to trademark fucked? And while you guys, decide what you want to do, I want to let you guys know you can go to the link in my bio, download my ebooks, go grab tickets to my intellectual property webinar. We're going to talk trademarks, copyrights, patents, all things intellectual property. We're going to have fun, all right? No opinions? For real? Okay, well, I'll let you know what I think. I don't know, because once your empress says go fucked. Okay, so you're all for it. Because you know what it makes me think of? It makes me think of how many of you remember the store French Connection? And they had shirts that had the and it was the initials FCUK, which stood for French Connection UK. But when you looked at it real fast, it looked like a vulgar word, right? So we'll see what happens with fucked. All right. Next case we're talking about today has to do with Kanye Kardashian. I used to be a big Kanye fan, not so much anymore. But this case was a really important case. This actually doesn't have to do with trademarks. This has to do with contracts. And I'm really glad it came up because it demonstrates a lot of things that I want people to know about contracts. Okay. So here's the thing that happened. Kanye is basically suing his music label EMI, saying that there is an unfair contract that prevents him from retiring as a songwriter. So he's basically saying, I don't want to make music no more, but I'm stuck in this contract. Okay. Here are the details of his contract. So EMI was going to handle Kanye West publishing. Kanye West's job was to write and deliver a minimum number of songs and at least 35-minute albums. Okay. He got hundreds of thousands of dollars in advances for this contract. In this contract, hi, New Haitian, how are you? In this contract, EMI had the ability to extend Kanye's contract and increase the number of songs that he was required to deliver. Okay. And they exercised this in 2005, 2006, 2009, 2011, and 2014. They did this with Kanye West's agreement. All right. Kanye West's legal team's argument is basically that with this clause in the contract, EMI could effectively keep him under contract forever. And California law, which is where Kanye filed his lawsuit, only says that contracts can only go for 7 years. Okay, so after 7 years, a contract in California is null and void. All right. According to Kanye's legal team, his contract with EMI should have been finished in 2010. EMI has copyrights to Kanye West songs as well. That was part of the contract. So what Kanye wants, he wants ownership of all the songs he created after 2010, and he wants all of the money that EMI made off of his music after 2010. So now, here's what EMI said. So remember, I said Kanye West filed this suit in California state court. EMI moved the case to federal court because copyrights, which is what Kanye is suing about, is a federal matter. Their argument is that Kanye just wants out of his contract. They said Kanye has a top team of lawyers. He's not just some struggling independent artist. He has people who know what they're doing, and he has the money and access to know what he's doing. He agreed to the contract extensions of his own free will, and on top of that, he got paid. Okay, the contract as well, they said, specified that if there were any contract issues, they had to be filed in New York. They basically said that he's doing something called forum shopping, where you find a court or a venue or a legal system that is going to be favorable to you, and you file your suit there. And that you can't always do that. You have unless a contract. Your contract will always state where you're supposed to file suit. So if I do a contract with someone, I'm going to say that we're going to be pursuant to the laws of Maryland. Their suit, the suit that they are suing under, Kanye went to California state court to sue for copyright infringement. And the team is saying, well, girl, copyrights are federal. They're not state specific. You filed for a federal copyright. So we're moving to federal court. And that's what they're doing now. So we're going to keep an eye on this case, see what happens, see if they let Kanye out of his contract. I actually had no idea that his contract went on for so long. I do think it's kind of unfair that they're able to extend it for so long. But on the other hand, he agreed to it and got money. It would be one thing if they were just able to change it and he wasn't getting his money or whatever. But you've been agreeing to it. So what's the problem, Kanye? All right. So do we have any questions? Do we have any comments about that story? Remember, you can pop in, you can talk to me, you can write your comments in there. I want to hear from you. What do you think about Kanye? Do you think that he should be let out of his contract? Do you think it's a fair contract? What do y'all think? If you think it is a fair contract, I want you to give me a star. If you think it's a fair contract, give me a star. If you think it is an unfair contract, give me a sad face. So if you think it's a fair contract, I want a star. If you think if it's an unfair contract, I want a sad face. And then we're going to move on to something really fun. What y'all think? My delay on Instagram, I think my delay on Instagram is really slow. Unfair. Okay, you think it's unfair, One True Empress? There's 3 more people in here. Y'all ain't responding? Fuck Kanye. Okay, well, you gave a sad face, though, so you think it's an unfair contract. All right, I got 2 for unfair. Okay. All right, I got 2 out of 4, you know. All right, I'll let y'all cook. Okay, so we're going to move on to another case, and this one is really fun for me. Oh, you think, yeah, it is. I don't know. I think it's partially unfair. He is always tripping. Miss Whitney said he's always tripping. Lorenzo said, if Kanye is agreeing to the extension and getting paid, he needs to just suck it up and crank out those bops. That's right. And see, this is what I want y'all to understand about contract. So a contract requires both parties to understand what's happening. That's why you're not allowed to get into contracts with minors, because and in the eyes of the law, a minor doesn't have the mental capacity to understand the agreement that they are making. Kanye is in his 30s, a millionaire, and with a crack legal team. While this contract is not necessarily the fairest, you are going into it with open eyes. So don't act surprised now. So thank you all for your participation. All right. Next case we are talking about the song. A lot of y'all weren't in here when I started, but I was playing Cash Doll's Ice Me Out. So, all right. If you were on my Instagram this week, you saw that I posted a picture of Cash Doll. She is a rapper, and she had a Louis Vuitton face mask with a rifle that was had Louis Vuitton wrapping around it, and a tactical vest that had Louis Vuitton patches on it. And I started thinking, I'm like, what does that mean in terms of trademarks and copyrights with fashion houses? Because the Louis Vuitton pattern is a trademark pattern. It's protected. You can't just use it. That's why you can, go to jail. That's one of the reasons why Dapper Dan got taken down. And I was wondering how she could get away with it. And I started doing some research on fashion law and being able to use luxury fabrics. And basically what happened is there is this trend in fashion now called upcycling, where you take old items and you rework them to, 1, help the environment, and 2, make something new again. And now there is a new trend of luxury upcycling. So that's where you buy, genuine, luxury goods, whatever they be, and then you buy it and you repurpose it. And when I was doing my research, they said the way that you get around the trademark laws for this is that you have to rework the fabric in such a way that there is no confusion. So when I'm taking the Cash Doll example, Cash Doll, she had the face mask and the gun and the tactical vest. We all know that Louis Vuitton is not making weaponry or tactical vests or anything having to do with, military attire. So anybody seeing that is going to be like, that is not a Louis Vuitton product. Okay. Now, on top of that, what else matters is that you need to buy the product. So if I buy an old Louis Vuitton purse, right? I have it, it's full, it's got all its paperwork, I buy it in the box, or even if I buy it new. Once I buy it, it's mine. If I want to go cut it up, shred it up, throw it in my backyard, staple it to my body, it's mine. I can do what I want with it. Hi, pretty pop-up shop. I haven't heard from you in forever. All right. Now, this applies when you're reworking something. So if I can take this Louis Vuitton bag and I can cut it up and make it into something different, I take a patch here, I put it on the face mask, nobody's going to confuse that for a Louis Vuitton product. And I already bought it. I get to do what I want with it. If I want to take it and wrap it around my head, that's what I can do. And that's what's called the first sale doctrine. It's when you buy the genuine product and you cut off the trademark rights because you already gave them their money. Okay, right? You already gave them their money, so it's like, girl, stop complaining. I gave you your however much the Louis cost, and now I'm going to do what I want with it. All right. And the other thing that how you can get away with these things is that you have to market it as an altered item. So what I see with a lot of these, Instagram boutiques, and I don't use Instagram boutique pejoratively, with these, boutiques on Instagram where they're marketing these products, is they call it custom. And that is a great way to say altered. What you're saying is, hey, I got the genuine, but I reworked it and I made it special. And they're selling it, and it's not a problem that way. So that is how people get away with that. And then I also thought about, well, what about if it's a piece of clothing and the label inside? And as a designer, you can change the label if you rework an old designer piece, but you still have to keep, records of the original piece for about 3 years. Okay. This can get really tricky on Etsy, and a lot of people get their stores shut down if there are trademark or copyright complaints. So keep that in mind if you're trying to open an Etsy store. All right. What's lies, Miss Whitney? While Miss Whitney, hi, Akron Confetti Company. While Miss Whitney tells me what's lies, again, I want to remind you guys, if you don't know who I am, I'm Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting, LLC, a business formation firm. That means is I help you get your business paperwork together, your contracts, your trademarking, your business formation, all that. Check out everything I do at Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm. You're going to find things like my intellectual property webinar that's coming up March 20, 2019, March 20, 2019, March 20, 2019. So go get your tickets because the webinar is next week. Those customs aren't real. Okay, so Miss Whitney, that is where the issue comes in. Miss Whitney says that the customs aren't real. We as the consumers, we probably don't know whether they're real or not. I'm sure as a designer, you're supposed to have some type of proof that you're working from actual, genuine materials. And I don't know how they do that because I ain't in fashion. However, when I had posted this on my Facebook, somebody brought up the Dapper Dan situation. And I did some research on Dapper Dan. And the reason that Dapper Dan got taken down was because he was printing his own fabrics. So he was not purchasing fabrics from these houses and making the outfits. He was just making his own, which is a trademark violation, which is a copyright violation. And that is why Dapper Dan got taken down. And now they're copying all his designs. All right. So that is my cash doll story. Okay. Next story we are talking about is a fun one. I want to know, I'm sure at least 50% of my audience owns an iPhone. Okay. And we all know who the founder of the iPhone was. Steve Jobs. I bet y'all didn't know Steve Jobs had a clothing line. Steve Jobs doesn't know either. But Apple knows, and Apple is pissed. Okay. So here's what happened. Basically, these two brothers in Italy, in 2012, they found out that Steve Jobs' name did not have a trademark, and they wanted to start a clothing and accessory line. So they named their clothing line Steve Jobs, and they applied for the trademark. And Apple found out about this and was like, whoa, what are you doing? And and with the European Union Intellectual Property Office, and was like, you can't do that. Steve, that's our guy. How are you going to try and trademark his name, right? And their issue was also the logo that they picked for the company. And I'm going to show it to y'all, okay? So Facebook, let me see if y'all can see it. Wait, here we go. Facebook. Here you go. Can you see? Oh, here you go. So look at that, Facebook. Okay, I don't know if it's backwards or not. And then Instagram, hold on one second. Let me get y'all. Instagram, this is what, can you see? This is what the logo looked like, that J. Their logo was a J with a, oh, you can't see? Okay, sorry. Anyway, I think my lighting is off, but the logo for the Steve Jobs clothing company is a J with a bite taken out of it. But Apple can't do anything about it because they don't own Steve Jobs' name, right? So these Italian brothers are going ahead with their clothing line, and they plan on releasing electronics soon. So we're gonna see how that pans out for them. Okay, but y'all go and get yourself some Steve Jobs jeans. All right. Next story, we are talking about how many of you guys wear contact lenses? If any of you guys have ever worn contact lenses, this could be coming near you soon. So there's a company called Novartis, and they actually do diabetic medications. They tried to trademark something called a smart surface because they developed a contact lens that could measure glucose levels for diabetic patients. Okay. However, they got denied because the USPTO office said that the name smart surface merely describes sophisticated surfaces. It doesn't, yeah, Miss Whitney, Dan, are you saying Dan about Steve Jobs or Dan about the lenses? But the name smart surface doesn't immediately denote, oh, this is Novartis's product. This is your specific contact lens. It just says it's a smart surface. So they got denied. And this is just to demonstrate that you cannot trademark generic words for your product. They need to be kind of specific. Okay. Yeah. Steve Jobs, that's kind of messed up, but it's brilliant. And this is why I say you got to protect yourself out here in these business streets. People are out here stalking. Next case we are talking about. Ooh, Miss Whitney, did you ever have a Barbie doll? How many of y'all have Barbie dolls? I had a Barbie doll. Did you have a Barbie doll, Miss Whitney? It is. Well, Miss Whitney tells me, oh, hey, I saw you. Don't leave. Okay. Did you have a Bratz doll, or have you heard of a Bratz doll? If you had a Bratz doll, give me a 1. If you've heard of a Bratz doll, give me a 2. Ooh. Ooh, 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 ooh. Because this is a very interesting case. And it's actually a very long one. Okay. but you know what a Bratz doll is. So we all know iconic Barbie, and we all remember Bratz dolls were around for a while. They had like the big heads, and they were very like, a lot of makeup and very stylish dolls, right? Okay. So I remember Bratz dolls just disappeared one day. They were just gone after a while. I bet y'all didn't know why they disappeared, and I'm about to tell you why. Okay. Basically, at the height of Bratz popularity, they cut Barbie sales by 12%. Okay. Bratz was created by a former clothing and accessories designer for Barbie. All right. So he goes and develops his own doll. This guy named Carter Bryant. Mattel, who owns Barbie, sued him for copyright infringement, trade secret appropriation, and breach of contract because under the terms of his contract, any inventions that he made became the property of Mattel. Okay? Or while he worked there. Anything that he made while he worked there became the property of Mattel. And Mattel wanted him to pay them a cool $30 million. All right? Bryant argued back. He said that the employment agreement that he signed, it was too overly broad and it wasn't fair and it was unenforceable. And on top of that, he said that he came up with the Bratz during an 8-month sabbatical in 1998. So basically he said, well, I came up with the Bratz while I was on vacation. Hi, Robbie A. And also your contract is unfair. So that was his argument. The court did not agree, but they only said that Bryant had to pay Mattel $2 million in royalties. Okay, so he paid him $2 million. Then Mattel went after the company that Bryant had partnered with, which was called MGA. So they sued them for $1 billion and the rights to the Bratz. They said that they had bribed Bryant and other employees, okay? MGA, the company that was distributing the Bratz, they said that regardless, even if Bryant came up with it, they were the ones who made Bratz what it was. They did the advertising, they built it up. Bratz would have been nothing without them. Mattel won that suit against MGA. They won $100 million damages, okay? Another judge stripped MGA of all their Bratz rights and said, you can't even make this doll anymore. So they had to pay Mattel $100 million and then they couldn't even make the doll anymore, okay? So that happened in 2008. MGA appealed that case in 2010. So they had to shut everything down. So that's why you haven't seen Bratz dolls around since around 2010. MGA, the company that was distributing Bratz dolls, they appealed the ruling, okay? And the court reversed that ruling, saying that MGA did actually put in a lot of work into developing the Bratz brand, and the other ruling was wrong. So they vacated most of the damages, meaning that they didn't have to pay all the damages, and the previous verdict, and they said that they should get a retrial. Okay, so retrial's coming soon. In the meantime, MGA sues Mattel for spying and trying to monopolize the doll market. And they said that they used their power and leverage and money as a company to basically litigate MGA to death, meaning they took MGA to court until the company died. Okay. And were intimidating their suppliers and vendors. They were apparently paying off vendors to set up their displays to put Barbies higher than Bratz, all that stuff, okay? But that case was dismissed, the case for spying, okay? That's in 2010. Now, 2011 comes, the retrial happens, and MGA wins. Now the court found that they did entice Bryant to come work with them, but they also found that Mattel had been spying and was using unfair business practices. So Mattel was then ordered to pay MGA $309 million for trade secret misappropriation, attorney's fees, and other costs. Mattel said they want a new trial, and the court said no. They're still fighting in court, okay? MGA sued for $1 billion in 2014. So now there is this question of who owns the rights to Bratz, because the creator of Bratz was essentially an employee of Barbie at the time that he created the Bratz. But MGA did put a lot of work in and built Bratz to what it was. So who owns the rights to Bratz, or should they share them? I want to hear your opinions. Okay. Okay. So we're going to go through a couple of quick stories, and then we're going to take a break and finish this off because we're about halfway done. Okay. So I'm calling this the bits and bytes. If you guys have ever tried to open a Shopify store, Shopify gets all of its supplies from Alibaba Express. You can, for Alibaba Express, they have, hi Joanne, you can find a lot of low cost goods on Alibaba. They sell a lot of like the generic versions of, a lot of them are the suppliers for what these Instagram boutiques are selling. Okay. Now, in the cryptocurrency world, someone named one of their coins the Alibaba coin. Okay. So I'm not going to go into cryptocurrency because it's a little difficult, but basically somebody tried to name some new money Alibaba coin. So Alibaba, the company, filed a complaint in the United States for trademark infringement. But it was rejected because the infringement did not happen in the United States. Meanwhile, the company that started Alibaba coin, they were like, well, Alibaba is a common word because the company that started the coin is based in Dubai. They said, well, this is a common word in Dubai, girl, so we don't think it's infringement. And on top of that, Alibaba, which is based in China, bans crypto coin offerings, these cryptocurrency offerings. So they're like, y'all don't even do cryptocurrency, so why do you care? Okay. The thing that killed Alibaba coin, though, is that they used materials using the trademarks of Alibaba, the company. So now Alibaba coin has to stop using the name. All right. Next quick one, Louboutin won another trademark battle, y'all. He won it in China, actually. So kudos to him in getting his red bottoms trademarked all over the world. Next, so a few weeks ago, I talked to you guys about a company being sued by Levi's for putting tabs on their jeans. All right. This company is called Barbour. Now, Barbour is owned by, it's called J Barbour. J Barbour owns the clothing. No, sorry. Let me rephrase. I told you guys about Levi suing a company. The company that Levi sued is owned by a company called J Barbour. When the suit happened, J Barbour said, well, that's our subsidiary. That's not us. So you can't sue us. And the court said, no, girl, because you advertise in California. So you are on the hook for this. Okay. So you have to be careful with your business structures and how you advertise because you can be on the hook for stuff. What is happening with my Instagram? Hold on, guys. Instagram is being difficult. Okay. All right. I'm going to end this and then I'm going to restart. Hold on. YouTube and Facebook. Give me 1 second. Okay. I got to put this back on. Woo. All right. Okay, guys, I don't know what was happening with the last broadcast, but it was freezing and I wanted you guys to hear this good info, so I just restarted it. So we were talking about Levi jeans. Oh, also, I wanted you guys to know that there is a case where a landlord is being held liable for their tenant's infringement. There are a series of cases where the owners of commercial properties who rent out to businesses who trademark infringe they're being held responsible because they should know what their tenants are doing on their property. So you need to be careful when you work with people. And those are my bits and bytes. Hey, sorry, the last broadcast started getting glitchy, so I got off and got back on. All right. Oh, update on the UPS case versus the cannabis delivery companies. So UPS, if you remember, I talked to you guys about this story of how UPS was suing 3 companies in California that were using similar logos and coloring and advertising for their cannabis companies. Well, UPS has now gotten a preliminary injunction, which means that these companies cannot use the names or the logos. And now they are trying to take ownership of the website domains of all of these companies. So if there are any more updates on that, I will keep you apprised. Oh, another update case for you, my darlings. If you remember, again, a few weeks ago, I talked about Nirvana suing Marc Jacobs for trademark and copyright infringement of their iconic smiley face symbol. Okay. So I'm going to show you guys a picture. Actually, no, I'm not going to show it to you because it didn't work last time. Anyway, basically, Marc Jacobs had released a line of grunge-inspired clothing that was obviously very inspired by Nirvana, including a t-shirt that mimicked a famous Nirvana t-shirt that had Nirvana, a smiley face with X's for eyes, the tongue sticking out. Marc Jacobs had his own that said, I want to say Marc Jacobs up top. No, it said something up top, and then it had M and J for eyes and the smiley face. And Nirvana was suing, saying that is our design. They were suing for copyright infringement. Okay. Marc Jacobs wants the case dismissed. They're saying that Nirvana thinks that they have a copyright, registration for the smiley face design. But what they're saying is that the smiley face design is only a copyright covers. The copyright covers the Nirvana on the top, the smiley face, and also some writing that's supposed to be on the back. Okay. Now, Nirvana's copyright registration covers the whole t-shirt is supposed to be this. It's supposed to be the smiley face, Nirvana above, and it's supposed to say flower sniffing, kitty petting, baby kissing, corporate rock whore on the back. So that is what their copyright is for. Marc Jacobs is also arguing that he's been using the smiley face since 1984, and Nirvana. Hey! Sorry, guys, my dogs. And that Nirvana doesn't just have a right to the smiley face; it has to be the whole design as a whole, and they didn't copy the whole design. All right. And on top of that, their other argument is that even with copyright registration, Nirvana didn't say how they got the rights to the smiley face from Kurt Cobain or the unknown creator of it. Because remember, the front man of Nirvana, if you don't know, was Kurt Cobain. He was like the lifeblood of that band. Also, their other argument is that while they are inspired by Nirvana, there's not enough similarity for infringement. And their other argument is that Nirvana's keeps saying that they have a state trademark, and Marc Jacobs is saying this is not right because Nirvana filed the trademark application on January 28th, 2019, after they filed suit and said that they intended to use it as a trademark on clothing, but failed to do so. But my only question is, Nirvana's thing came out like over 20 years ago. If you were going to make a clothing line, why didn't you start already? Why are you doing it now? I don't think Marc Jacobs is right. But why is Nirvana just doing this now? Okay. And this could make or break their case, because if Nirvana is saying that they already had a trademark, but they haven't done anything with it, you can lose your trademark if you don't do anything with it. Okay? So we got to see what's going on with that. So Marc Jacobs is saying you never used your trademark. Nirvana's they sold shirts with the design on it, but they never use it as a trademark. Now understand, if you have a clothing line and you're trying to trademark your clothing line, the stuff that you put on the front of your shirt, that is not trademarkable. You can copyright it maybe, but you can't trademark it. What you can trademark is your label. That's what the trademark is, and it goes on your label. Okay, so just because it's on your shirt, just because you sold it on your shirt doesn't mean that you have a trademark to it. Okay. Also, Marc Jacobs said that Courtney Love knew who is Kurt Cobain's widow. She knew that Marc Jacobs has been using the smiley face and seemed to approve because she, would comment on social media very positive things. So we're going to keep an eye on that. We're going to see who wins. I don't know who's right in this, because Nirvana, it just seems like this just seems like a case of waiting till the last minute, just like with Alfonso Ribeiro and the Fortnite dance. Now, granted, he didn't create it, but if he had wanted to assert some rights, he probably wasn't even thinking about it because he was a kid. But had he asserted his rights early, maybe things would have turned out better for him in the Fortnite case as well. Okay. So guys, we are almost done. It is time for a commercial break. Anybody who's just tuning in, I'm Natalie Pierre-Lewis, the business formation boss. I'm here to get your business off the ground. Go to the link in my bio, linktree/NPL consulting firm. See all the things I do, like my intellectual property webinar that's coming up March 20, 2019. Tickets are only $25, and it's next week. Get them, okay? Next story we are talking about, has to do with candy. I hope you guys like candy. So this is a $2 million candy case, y'all. How many, if you had to add up all the money that you spent on candy, how much do you think you have spent in your lifetime? I want to hear some numbers while I talk about the details of this. So this is the case of Sugarfina versus Sweet Pea. Okay. Now, Sugarfina is a very upper crust, sophisticated candy store, and they sued Sweet Pea because they said they copied packaging design and product names with their candies. Okay. Sugarfina has trademarks on their products. Specifically, they're saying that Sweet Pea copied a 3x3 bento box of clear cubes and a cola flavored gummy called Cuba Libre. So they were both selling these Cuba Libre candies, right? Now, Sugarfina started with one store in Beverly Hills, but they now have 30 stores plus pop-in shops at more than 12 Nordstroms around the country. Sweet Pete debuted on this show called The Prophet, and is majority owned by some celebrity host called Marcus Lemonis. I don't know who he is. And they have one store in Jacksonville, Florida. So I'm pretty sure, well, I'm not pretty sure, but yeah. So Sugarfina, asserted their rights against this interloper coming and trying to steal their candy name. Candy, it's not that sweet. Candy cane. Okay. All right. Wow, guys. Okay. Next story we are talking about. All you car lovers out there, Jaguar, the luxury car company, is suing a company called Bombardier. Okay. I'm going to tell you why. So Jaguar wants $130 million because Bombardier came out with an off-road vehicle and named it the Defender. Jaguar had also had an off-road vehicle named the Defender. However, this vehicle stopped being sold in the United States in the 90s because it did not comply with U.S. safety laws. Okay? So they stopped selling in the 90s, but they still had the trademark. The defendant, Bombardier, is saying basically that Jaguar abandoned the trademark because they didn't sell the car anymore. And the name of their car was called the Can-Am Defender. And it was a car that was for off-road use only. So the Jaguar car, you could drive it as a regular car. But the one that Bombardier was selling, you couldn't even get a license to drive it on the road. So they're saying that there was no way that there could be confusion. Okay. They're also saying that Jaguar, if what Jaguar is saying is right and they still have the trademark, then they kept it fraudulently because they haven't used it in about 20 years. Okay. So the first jury said, so this had been tried before. The first jury said that there was no infringement, but that also Jaguar had not abandoned their trademark. So we're going to wait and see what happens with this case. I don't know who's going to win, but we shall see. Jaguar or Bombardier. Quick anecdote. I remember when I first moved to this area, I went on a date with this guy and he showed up in a Jaguar and immediately told me, yeah, that's my sister's car. I live in her basement. All right. Guys, we only have 2 more stories. And I think they're pretty fun. How many of you guys have seen that My Pillow commercial with that guy with a lot of energy? Mike Liddell or whatever his name is, okay? Anyway, his company is called My Pillow. There is another company called I Love My Pillow, all right? My Pillow sued I Love My Pillow for trademark infringement last year. I Love My Pillow just filed a countersuit. Here's what happened. My Pillow, we've all seen the commercials, the guy, you're going to love this pillow, I'm a sleep expert. I bet y'all didn't know he had a crack problem and it cost him his marriage and almost his business. He had a crack problem, y'all, and he's a Trump supporter, so in the trash box with him. Anyway, My Pillow, his company, is 3 years older than I Love My Pillow. They both make memory foam-like pillows, right? And when they both came on the scene, they were like, I see you, I see you. They were kind of fighting, but then they signed a coexistence agreement in 2013. My Pillow is saying that I Love My Pillow violated the coexistence agreement because when they were doing Google search ads, they purchased the terms my and pillow, which I guess was against the agreement. As well, they had emailed wholesalers and said specifically that they could go head to head with competitors like My Pillow. So My Pillow wants I Love My Pillow to surrender their site, to stop using their phrase I Love My Pillow and the design, which is I Heart My Pillow, and to take back and destroy whatever merchandise they have out there. So they're like, we want to burn it to the ground. My Pillow wants I Love My Pillow out of here. Okay. I Love My Pillow says that they fixed the ad mistake in time. So they admit that they did purchase My Pillow for Google search ads, but that they fixed it within the time allowed for the deal. So apparently there was a clause for that. They also said that My Pillow itself was using false advertisement because they were claiming that the company owner was a sleep expert, and they were putting that in his commercials, and they actually had to pay $1 million in damages because it was not true. On top of that, the Better Business Bureau downgraded My Pillow's rating from A+ to F because they had this offer that you buy one pillow, you get one free, but and it was supposed to happen in 30 days, but apparently it wasn't happening and people were complaining. So they got downgraded to an F child. Okay. I Love My Pillow also saying that My Pillow is also committing fraud because they claim that there was like some big study that they did and it was scientifically approved. However, the study was backed by, hey, Erica, America, the study was backed by My Pillow. So they funded their own study and it just wasn't done right. And then after I Love My Pillow made these claims, My Pillow went back and quickly changed their site. So My Pillow is on some BS, okay? But we're going to wait and see who wins for that. I don't think My Pillow is going to win because their practices are just as shady as I Love My Pillow, all right? And the last case we are talking about has to do with, a little known family. You might have heard of them, you might have not. They're called the Marleys. A while ago, I talk to you guys about a story with the Marleys, where they were their licensing company, Hope Road Merchandising, was suing Jam and Java for using their image and words and things like that without permission. Other people keep trying the Marley family. So there is a company in Florida. It's called the Sandal Factory. They do beach wear. It's a beach retailer. Okay. They've been trying to trademark the phrase gnarly Marley to use on their beachwear. Now, Hope Road Merchandising won. And I'm going to tell you why they should have won. Whenever you hear the name Marley, you immediately think of Bob Marley. His name is synonymous, and his family has worked very hard to maintain their rights. And they're not going to let anybody take that away because they eating off that money. Okay. Second thing with the Marleys is they also got tried by a film company. So this film company basically tried to prevent them from asserting their copyright rights to their copyrights to for Bob Marley's music, because this film company was making a music about Bob Marley's life and wanted to use his music, but didn't want to have to get licensing from the family. However, what saved the Marley family was that this film was not yet finished. There was no end date in sight, and there was no immediate need to bypass the copyright. So the Marleys are saved once again. So that is the end of the show, guys. This is my longest show today. I have never gone an hour, and I am parched. But thank you so much for hanging in there with me. Remember to get your tickets for the intellectual property webinar. Tickets for $25. It's taking place next week. You're going to get all 3 copies of the intellectual property books in my all 3 copies of the books in my intellectual property series, as well as the recording of the webinar when it's done. I would love to have you in there so we can dish and chat. If you have any questions about the stories that I talk about, if you have any comments, DM me, set up a conversation. Let's talk, y'all. I'm going to go get me some water. Bye. Bye, YouTube.